Hi everyone, I'm Sabrina.
And I'm Jonathan, and we are the lawyers at Verity Law.
If you're thinking of buying a business, the first question is whether you should buy its shares or its assets.
Making the wrong choice can have serious consequences. If you make the wrong choice, you could inherit the seller's debts and litigation, or you could lose existing clients.
So, what choice is right for you? Today, we will explore the pros and cons of share versus assets purchase.
For the sake of argument, I will support share purchase.
And I will support asset purchase. Let's dive in.
If you're buying all of the shares of a company, that means you are taking over the entire company, including its business bank accounts. So, if I'm buying a restaurant called ABC Restaurant, I take over the whole restaurant, including its location, its existing clients, and its brand. ABC Restaurant would remain unchanged and the new owner continuing to operate it.
In contrast, if you're buying assets, then you're only buying the goods in a company, such as its equipment and inventory. Using the same example of ABC Restaurant, that means I'm only buying its assets, including its tables and chairs, kitchen equipment, fridge, and other physical assets. Usually, I do not inherit the name ABC Restaurant. This means that the old owner could go to a different location and open another ABC restaurant.
Exactly. The biggest benefit of a share purchase is that I inherit the seller's goodwill. ABC Restaurant's customers are now my customers.
But goodwill is not guaranteed. It depends on whether the customer chooses to stay with ABC Restaurant or choose to leave with the previous owner, Mary. So let's say everyone goes to ABC Restaurant because they like Mary as a person, then after she leaves, they will just follow her to her new restaurant. You don't inherit any customers automatically.
That is true, but if they like ABC Restaurant because of the restaurant itself, then they will continue coming here, even though the new owner has changed.
Well, that is right. So the lesson is share purchase likely means you can inherit the customers, but it is not guaranteed.
But in an asset purchase, the chances of inheriting the customer is even lower.
Well, that's true, because all I'm doing is buying the equipment, inventories, and other physical assets. I'm not inheriting the business name or its brand. However, I could negotiate with the seller to inherit their business name, and I could also put a non-compete clause so the seller cannot open a similar business in my area.
That is true, and your lawyer would be able to do both of those things for you.
Exactly. Then I would inherit the customers if they just come back to the same location. Okay, next, let's talk about bank accounts and tax accounts.
Well, with a share purchase, you do not need to get new bank accounts or tax accounts. You simply take over the seller's accounts.
That's right. With an asset purchase, you have to set up a new company with a new bank account and a new tax account. But at the same time, you won't inherit any problems with the seller's bank accounts.
That's true. If the seller's company has debts, litigation, or government violations, then I will inherit them as the buyer. But if I have a great lawyer and accountant who will do their searches for me, then my risk is greatly reduced.
Okay, so if during the search process, the lawyer does discover debts and litigation, how could they resolve it?
Well, they would require that the seller take care of those problems before completing the sale, and only then would the buyer take over the company. Of course, such requirements should also be noted in the offer signed by both parties.
Sounds good. In contrast, with an asset purchase, you won't need to worry about those things since you are only buying the assets, not the company.
But you must ensure there are no debts registered on the assets themselves. It is common for a seller to get a loan to purchase an expensive asset, like an industrial fridge. In that case, there would be a PPSA lien registered on that fridge.
True. So your lawyer must do searches against the assets and against the seller to ensure everything you're buying is problem free.
What about the contracts signed by the seller? In a share purchase, you will inherit all existing contracts, including those signed with the clients, suppliers, and employees. Be careful here. Your lawyer should read the contracts carefully to see what happens when there's a change of ownership. If the contract does not say, then a new contract should be negotiated.
Now, here's the difference. When it's an asset purchase, you do not inherit any contracts unless they relate to the assets directly. So, for example, you will inherit a supplier contract providing the company with kitchen equipment and inventories and any repairs they may be making. If you're going to inherit a supplier contract, you should be contacting the supplier or you should negotiate a new contract.
Next, let's talk about real estate. In most cases, the seller does not own the real estate housing the business. They lease it from the landlord. So, in the case of ABC Restaurant, the seller leases the restaurant premises from the landlord. In an asset purchase, the landlord must agree to assign the lease to the new buyer. Otherwise, the new owner cannot take over the restaurant.
Okay, and is this lease assignment process difficult?
It depends on the landlord. They will assess to see if the buyer can reasonably afford to pay the rent. Lease assignment is less of a problem in a share purchase. In most cases, the lease signed by the company and the landlord remains unchanged, even if the owner of the company changed through a share purchase. The only exception is if there is a change of corporate control clause in the lease. If you're unsure about this, feel free to contact us to take a look.
That's great. Now, in contrast, for an asset purchase, you always need landlord consent. The realtor should always include a landlord consent clause in the offer. The buyer should be able to back out of the purchase if the landlord refuses to assign the lease.
Now, the offer should also state who will pay for the landlord's assignment fee, the buyer or the seller. This is usually thousands, if not tens of thousands of dollars, so it must be clearly stated in the offer.
Okay, so now what if the business premises is not leased, but is actually bought and owned by the seller?
Well, if the premises is owned under the company that you're purchasing, ABC Restaurant, then the share purchase is definitely better. When purchasing the company, you would get both the restaurant business and the real estate that houses the restaurant.
Well, this is not guaranteed, but usually landlords do not put real estate under the operating company that you're purchasing. They will put it under a different holding company. So if you're not buying the holding company, you will not get the real estate with the share purchase.
True, but with an asset purchase, you definitely do not get the real estate since you're not purchasing the company to begin with.
Well, that's right. But at the same time, you won't inherit any problems that may come with the real estate, such as registered mortgages and litigation.
But again, those problems could be solved by your lawyer doing the proper searches and making the correct request to the seller to take care of them in advance.
Okay, so what's the verdict?
Well, in terms of inheriting clients, share purchase is definitely the better way to go. As long as the clients recognize the business by its company name, ABC Restaurant, and not by the specific owner's name, Mary, then the new owner would inherit those clients.
True. With asset purchase, you only get the equipment, inventory, and other physical assets. However, you can negotiate with the seller to continue using their business name and forbid them from opening a competing business nearby. Ensure you write both requirements in your offer and legal documents.
And in terms of inheriting bank and tax accounts, it is more convenient with a share purchase. You inherit everything without having to open any new accounts yourself.
Yes, but you also inherit all the bad things, such as debt and litigation. Of course, your lawyer could do the proper searches and ask the seller to resolve all problems beforehand. Regardless, with an asset purchase, the risk of inheriting bad things is lower, as long as the assets themselves have no debt attached, as confirmed by your lawyer, then you're safe.
In terms of real estate, share purchase is definitely better. If the real estate is owned by the operating company, ABC Restaurant, then you get it with the purchase. If the real estate is leased by ABC Restaurant, then the lease assignment is easier with a share purchase.
That's true. The landlord's consent must be given for an asset purchase, and this should be written into the offer. If the landlord does not give permission to lease to the new owner, the buyer should be able to back out of the deal with the deposits returned.
In the end, there is no right answer. It's not a one-size-fits-all situation. It depends on what fits you the best, share or asset purchase.
All right, that is all for today. We will see you next month.